United States v. Watson, Supreme Court, 1976. Justice White delivered the opinion of the court. This case presents question under the Fourth Amendment as to the legality of a warrantless arrest and of an ensuing search of the arrestee's automobile carried out with his purported consent. 1. The relevant events began on August 17, 1972, when an informant, one Corey, telephoned a postal inspector informing him that respondent Watson was in possession of a stolen credit card and had asked Corey to cooperate in using the card to their mutual advantage. On 5 to 10 previous occasions, Corey had provided the inspector with reliable information on postal inspection matters, some involving Watson. Later that day, Corey delivered the card to the inspector. On learning that Watson had agreed to furnish additional cards, the inspector asked Corey to arrange to meet with Watson. Corey did so, a business meeting scheduled for August 22nd. Watson canceled that engagement, but at noon on August 23rd, Corey met with Watson at a restaurant designated by the latter. Corey had been instructed that if Watson had additional stolen credit cards, Corey was to give a designated signal. The signal was given, the officers closed in, and Watson was forthwith arrested. He was removed from the restaurant to the street where he was given the warnings required by Miranda v. Arizona. A search having revealed that Watson had no credit cards on his person, the inspector asked if he could look inside Watson's car, which was standing within view. Watson said, "Go ahead," and repeated these words when the inspector cautioned that, "If I find anything, it's going to go against you." Using keys furnished by Watson, the inspector entered the car and found, under the floor mat, an envelope containing 2 credit cards in the names of other persons. These cards were the basis of 2 counts of a 4-count indictment charging Watson with possessing stolen mail. Prior to trial, Watson moved to suppress the cards, claiming that his arrest was illegal for want of probable cause and an arrest warrant, and that his consent to search the car was involuntary and ineffective because he had not been told that he could withhold consent. The motion was denied, and Watson was convicted of illegally possessing the 2 cards seized from his car. 2. Contrary to the Court of Appeals' view, Watson's arrest was not invalid because executed without a warrant. Title 18 U.S.C. Section 3061A3 expressly empowers the Board of Governors of the Postal Service to authorize Postal Service officers and employees performing duties related to the inspection of postal matters to make arrests without warrant for felonies cognizable under the laws of the United States if they have reasonable grounds to believe that the person to be arrested has committed or is committing such a felony. Because there was probable cause in this case to believe that Watson had violated Section 1708, the inspector and his subordinates, in arresting Watson, were acting strictly in accordance with the governing statute and regulations. Section 3061 represents a judgment by Congress that it is not unreasonable under the Fourth Amendment for postal inspectors to arrest without a warrant, provided they have probable cause to do so. This was not an isolated or quixotic, Quixotic, whatever that is, isolated or quixotic judgment of the legislative branch. Other federal law enforcement officers have expressly authorized by statute for many years to make felony arrests on probable cause but without a warrant. This is true of United States Marshals and of agents of the Federal Bureau of Investigation, the Drug Enforcement Administration, the Secret Service, and the Customs Service. Because there is a strong presumption of constitutionality due to an act of Congress, especially when it turns on what is reasonable, obviously the court should be reluctant to decide that a search thus authorized by Congress was unreasonable, and that the act was therefore unconstitutional. Moreover, there is nothing in the court's prior cases indicating that under the Fourth Amendment a warrant is required to make a valid arrest for a felony. Indeed, the relevant prior decisions are uniformly to the contrary. The usual rule is that a police officer may arrest without a warrant one believed by the officer upon reasonable cause to have been guilty of a felony. The cases construing the Fourth Amendment thus reflect the ancient common law rule that a peace officer was permitted to arrest without a warrant for misdemeanor or felony committed in his presence, as well as for a felony not committed in his presence if there was reasonable ground for making the arrest. This has also been the prevailing rule under state constitutions and statutes. The rule of the common law that a peace officer or a private citizen may arrest a felon without a warrant has generally held by the courts of the several states to be in force in cases of felony punishable by the civil tribunals. Watson's arrest did not violate the Fourth Amendment, and the Court of Appeals erred in holding to the contrary, because our judgment is that Watson's arrest comported with the Fourth Amendment. Watson's consent to the search of his car was not the product of an illegal arrest. There's a dissent. It looks important. Justice Marshall, with whom Justice Brennan joins, dissenting. By granting police broad powers to make warrantless arrests, the court today sharply reverses the course of our modern decisions construing the warrant clause of the Fourth Amendment. 1. Before addressing what the court does today, I note what it does not do. It does not decide this case on the narrow question that is presented. That is, unfortunately, for this is fundamentally a simple case. On the afternoon of August 23, 1972, Awad Corey, an informant of proved reliability, met with Respondent Watson at a public restaurant under the surveillance of 2 postal inspectors. Corey was under instructions to light a cigarette as a signal to the watching agents if Watson was in possession of stolen credit cards. Corey lit a cigarette, and the postal inspectors moved in, made the arrest, and ultimately discovered under the floor mat of Watson's automobile the stolen credit cards that formed the basis of Watson's conviction and this appeal. The signal of the reliable informant that Watson was in possession of stolen credit cards gave the postal inspectors probable cause to make the arrest. This probable cause was separate and distinct from the probable cause relating to the offense 6 days earlier and provided an adequate independent basis for the arrest. Whether or not a warrant ordinarily is required prior to making an arrest, no warrant is required when exigent circumstances are present. When law enforcement officers have probable cause to believe that an offense is taking place in their presence and that the suspect is at that moment in possession of the evidence, exigent circumstances exist. Delay could cause the escape of the suspect or the destruction of the evidence. Accordingly, Watson's warrantless arrest was valid under the recognized exigent circumstances exception to the warrant requirement, and the court has no occasion to consider whether a warrant would otherwise be necessary. This conclusion should properly dispose of the case before us. Since, for reasons it leaves unexpressed, the court does not take this traditional course, I am constrained to express my views on the issues it unnecessarily decides. The court reaches its conclusion that a warrant is not necessary for a police officer to make an arrest in a public place so long as he has probable cause to believe a felony has been committed on the basis of its views of precedent and history. An examination of the history relied on by the court shows that it does not support the conclusion laid upon it. There is no doubt that by reference to the seizure of persons, the Fourth Amendment was intended to apply to arrests. Indeed, we have often considered whether arrests were made in conformity with the Fourth Amendment. Admittedly, as the court observes, some of our decisions make passing reference to the common law rule on arrests. However, none of the cases cited by the court, nor any other warrantless arrest case in this court, mandates this decision announced today. Frequently, exigent circumstances were present so that the warrantless arrest was proper even if a warrant ordinarily may be required. Many cases have invalidated arrests as not based on probable cause, thereby bypassing the need to reach the warrant question. Elsewhere, the court has simply assumed the propriety of the arrest and resolved the case before it on other grounds. The court next turns to history. It relies on the English common law rule of arrest and the many state and federal statutes following it. There are 2 serious flaws in this approach. First, as a matter of factual analysis, the substance of the ancient common law rule provides no support for the far-reaching modern rule that the court fashions on its model. Second, as a matter of doctrine, the long-standing existence of a government practice does not immunize the practice from scrutiny under the mandate of our Constitution. In sum, the court's opinion is without foundation. It relies on precedents that are not precedents. It relies on history that offers no clear rule to impose, but only conflicting interests to balance. It relies on statute that constitute, at best, no more than an aid to construction. The court never grapples with the warrant requirement of the Fourth Amendment, and the case is construing it. It simply announces by ipsa dixit a rule squarely rejecting the warrant requirements we have favored for so long. The court has typically engaged in a 2-part analysis in deciding whether the presumption favoring a warrant should be given effect in situations where a warrant has not previously been clearly required. Utilizing that approach, we must now consider 1. Whether the privacy of our citizens will be better protected by ordinarily requiring a warrant to be issued before they may be arrested, and 2. Whether a warrant requirement would unduly burden legitimate governmental interests. The first question is easily answered. Of course, the privacy of our citizens will be better protected by a warrant requirement. We have recognized that the Fourth Amendment protects people, not places. Indeed, the privacy guaranteed by the Fourth Amendment is quintessentially personal. Thus, a warrant is required in search situations not because of some high regard for property, but because of our regard for the individual and his interests in his possessions and person. Not only is the Fourth Amendment directly addressed to the privacy of our citizens, but it speaks in indistinguishable terms about the freedom of both persons and property from unreasonable seizures. A warrant is required in the search situation to protect the privacy of the individual, but there can be no less invasion of privacy when the individual himself, rather than his property, is searched and seized. Indeed, an unjustified arrest that forces the individual temporarily to forfeit his right to control his person and movements and interrupts the course of his daily business may be more intrusive than an unjustified search. A warrant requirement for arrests would, of course, minimize the possibility that such an intrusion into the individual's sacred sphere of personal privacy would occur on less than probable cause. Primarily for this reason, a warrant is required for searches. Surely there is no reason to place greater trust in the partisan assessment of a police officer that there is probable cause for an arrest than in his determination that probable cause exists for a search. We come then to the second part of the warrant test, whether a warrant requirement would unduly burden legitimate law enforcement interests. I believe, however, that the suggested concerns are wholly illusory. Illusory? I think it's illusory. Indeed, the argument that a warrant requirement for arrests would be an onerous chore for the police seems somewhat anomalous in light of the government's concession that it is the standard practice of the Federal Bureau of Investigation to present its evidence to the United States Attorney and to obtain a warrant before making an arrest. In the past, the practice and experience of the FBI have been taken as a substantial indication that no intolerable burden would be presented by a proposed rule of procedure. There is no reason to accord less deference to the FBI practice here. The government's assertion that a warrant requirement would impose an intolerable burden stems, in large part, from the specious supposition that procurement of an arrest warrant would be necessary as soon as probable cause ripens. There is no requirement that a search warrant be obtained the moment the police have probable cause to search. The rule is only that present probable cause be shown and a warrant obtained before a search is undertaken. The same rule should obtain for arrest warrants, where it may even make more sense. Certainly, there is less need for prompt procurement of a warrant in the arrest situation. Unlike probable cause to search, probable cause to arrest, once formed, will continue to exist for the indefinite future, at least if no intervening exculpatory facts come to light. This sensible approach obviates most of the difficulties that have been suggested with an arrest warrant rule. Police would not have to cut their investigation short the moment they obtain probable cause, nor would undercover agents be forced to suddenly to terminate their work and forfeit their covers. Moreover, if in the course of the continued police investigation exigent circumstances develop that demand an immediate arrest, that arrest may be made without fear of unconstitutionality so long as the exigency was unanticipated and not used to avoid the arrest warrant requirement. Likewise, if in the course of the continued investigation police uncover evidence tying the suspect to another crime, they may immediately arrest him for that crime if exigency demands it, and still be in full conformity with the warrant rule. This is why the arrest in this case was not improper. Other than where police attempt to evade the warrant requirement, the rule would invalidate an arrest only in the obvious situation, where police, with probable cause but without exigent circumstances, set out to arrest a suspect. Such an arrest must be void, even if exigency develops in the course of the arrest that would ordinarily validate it. Otherwise, the warrant requirement would be reduced to a toothless prescription.